Can everyone hear us? Great. All right. Well, thank you everyone for joining us today. For those of you who don't know me, my name is Matt Spain. I'm a partner with Bolin Robinson and Ellis. And Josh Rohrscheib is presenting with me as well today. He is also a partner. And we wanted to talk to you a little bit today about succession planning. You know, we often, as attorneys, preach to our clients and talk to our clients about the importance of estate planning and you know, planning for your disability or for you know, your death. And sometimes as attorneys, we don't do such a great job of doing that for ourselves. And so we thought we would put this together today for folks to get some more information and take a look at what their plan is for retirement, or if they were to have to leave their practice. So this is a good example of what often happens. You know, a lot of times we as attorneys just kind of wait and do nothing. So we thought this was kind of funny. This is also often, if we are going to leave our practice on our own, oftentimes an example of how we handle that and just kind of wait until the last minute. So hopefully we can share some information with you today that will prevent either of these situations from happening. So, you know, first off, we want to talk about what is a succession plan. There are really, you know, two arenas in which, you know, you can use something like this. The first would be, you know, if there's an unexpected exit or absence from your practice. Of course, you know, this is, you know, if you become disabled or pass away or, you know, have to leave your practice for some unexpected reason. And we're kind of go through, you know, some of the requirements. And then also, you know, a planned exit strategy, if you want to work towards retirement or, you know, get yourself ready to transition out of practice. So the Illinois Rules of Professional Conduct do, of course, address, you know, our duties of diligence to our clients, and having a succession plan falls under that duty. Comment 5 to the rule talks about specifically a duty of sole practitioners to have a succession plan in place that designates another competent attorney to review the files, notify clients of the lawyer's, you know, death or disability, and determine whether or not there's a need for immediate protective action.
I'd like to join Matt in just thanking you all for taking the time to come to this presentation. This is really about protecting your firm, your clients, and your family. And that's the whole point of succession planning. So the risks and consequences of the failure to plan really affect those issues. For a lot of us, our practice is our most valuable asset. So losing the value of your practice by having a sudden event cause your departure without a plan in place can be economically devastating to a lawyer. It can lead to a loss of income. To the folks who may be working for you 10, 20 plus years, it can create chaos for employees and leave them with no job and a lot of uncertainty. It can also create chaos for your clients, which can lead to really adverse outcomes in their cases, can lead to malpractice charges, ARDC complaints. So the consequences of failing to plan can be really serious. And it's troubling because a whole lot of lawyers don't have a plan. We believe soon the ARDC is going to ask you if you have a plan when you renew. But from a few years ago, we have some data that in 2016, the overwhelming majority of solos didn't have a plan in place. Like 77% said, no, we don't have a plan. Kind of curiously, another 7 said they don't know if they have a plan, which I think really means that like 84% did not have a plan. And even apart from solos, I think a lot of firms might respond, yeah, we have a plan. The plan is we've got a lot of this, but only 26% of firms have actually bothered putting together a written succession plan. And this is a problem because we don't have a lot of new lawyers coming to downstate Illinois, which we'll talk about a little later. And a lot of our legal workforce downstate are folks who are, you know, over 55. So, and more broadly speaking, more than half of the legal workforce is over 55. So part of this process is uncomfortable, and we'd like to ask yourselves, you'd like you to ask yourselves a couple really tough questions. What would happen if you didn't make it in tomorrow? What would happen if you couldn't work for a month or 3 months or 6 months? Would your firm survive? Would your bills get paid? Would you get paid? Would you still have some kind of stream of income for your family? What would happen to your staff? As you're sitting here, can you think of deadlines that might be missed, or clients that maybe have been loyal clients to you and your firm for a long time that might not be retained? It's important to just pause for a moment in the day-to-day busyness of our practices and ask about the implications of death or disability. One other note, we'll talk about this a little bit more later, but do you have disability insurance, and what does it actually cover? What's the definition of disability? For some of us in firms, we have group plans. A lot of the group plans aren't great. For a lot of solos, you may have no disability insurance at all. And as we've seen in our firm, we had lawyers at 39 and 45 have disabling events. So it's a really bad idea not to carry disability coverage. Matt?
Thanks, Josh. So I kind of want to talk about some of the goals, when you're planning to not exist, sorry, that's a typo, planning to exit or transition, out, you want to, of course, realize the benefit from the value of your practice. That should be one goal, as a planned retirement. Your practice does have some value. You want to make sure that you care for your clients and make sure that they're well taken care of. Find a home for your staff. If you have, staff that has done well for you, and you want to make sure that they have a plan if they want to continue to work, that they have a home. Facilitate a transition out on your terms. That's always better. We always say if you fail to plan, you plan to fail, and you want to make sure that you control the terms of your exit. So that may mean that you want to pare down your practice and continue working for just a few hours. Maybe you're tired, if you're a sole practitioner, maybe you're tired of all of the back end aspects of running a practice, and you want someone else to handle that, and you just want to practice law, or if you want to just make a clean break. You want the ability to decide those terms for yourself and in conjunction with whoever the successor attorney is going to be. So we want to talk about, some of the exit strategies for solo practitioners. Of course, you can just merely wind up your practice and close. You can try to sell your practice. Another option is to look at hiring an associate to sort of take over, that you can, train and transition into taking over for your clients, or, developing an of-counsel relationship with an existing firm that you can transition your clients over to, excuse me, at the time in which you decide to completely quit practicing.
Before we get into that, we wanted to talk about one bit of context for lawyers like all of you who are downstate lawyers. There really is a challenge that's already taking place that is only going to get worse. And that is we have too few new attorneys in downstate Illinois. The data here is from the To Civility blog for the Supreme Court Professionalism Committee, but you can see 39 counties of the 102 in Illinois had no new attorneys in the previous 4 years. Another 76 had 5 or fewer new attorneys in 4 years. So in rural counties, this is just an important backdrop for the discussion about coming up with your own succession plan. A few implications of this: if you're wanting to sell your practice, you're going to have a limited supply of buyers. So, for the very few new attorneys that are coming downstate, fewer still will have the assets to buy the practice. And some may or may not have the skill sets you're looking for. So this may make of-counsel relationships more appealing. It may create more competition for promising young talent with you and your peers if you're thinking about someone to take over your practice. May make you want to be a little more aggressive in offers. For younger lawyers who are coming downstate, I think it means there could be a lot of opportunities. So if you have friends or mentors who are thinking about practicing law in downstate Illinois, maybe share some of this data with them, and the fact that there are two ways to look at it. One is certainly that there are going to be a lot of lawyers in the next 10 years who are transitioning out who have robust books of business that they may be able to partner with and be part of a solution for their plan.
So let's kind of go through some of the different strategies and some of the pros and cons. So the first one, of course, is to just close, without really any sort of plan. I think we see this is the most common result. This is what a lot of attorneys do. They just decide that they're going to retire and shut down, and that's it. Or, in the alternative, they don't get to decide that they want to shut down, and something makes them have to quit practicing law. Often takes place in an unexpected time, and you're just often not prepared. A lot of us assume that we're invincible and we're going to be able to practice for the rest of our lives, and sometimes things happen that prevent us from being able to do that. When you get into a situation like this, it's going to, of course, cost you. There's a loss of value to your business. You're not really taking care of your clients the way that you want to, as an attorney that cares about what's going to happen to your clients in the future. And, the folks that have worked for you, sometimes for years or even decades, are left just sort of dangling with no prospect of employment. Of course, the other option would be to sell your practice. And, some attorneys choose to do this. It's often difficult to value, what is my practice worth? Clients are not required to stay with anybody that you sell your practice to. But there are things to look at that, can help you value your practice. Do you have institutional clients, corporate clients, clients that are a continuing source of revenue for you? Oftentimes those who practice family law, those cases, unfortunately sometimes continue for years without a final resolution, or new issues arise, and those clients are going to need further representation. Do you have personal injury cases that are going to pay out, sometime in the future? That all can play into the value for practice. Of course, it's only worth what someone's going to pay for it. So this sometimes is a difficult thing to do. And as Josh talked about, with especially in downstate Illinois, the fewer number of younger attorneys that are moving into the rural areas, such as ours, or such as a market like Decatur, there are fewer buyers that may be available to you. And you also, you've got to look at, what's going to happen to your transitioning clients, and, be able to talk to an attorney that may want to buy your practice about, retaining those clients. Some of the things that are recommended that attorneys can do, or that you can do to help increase the value of your practice if you do choose to sell, keeping well-maintained books. If you're able to show that you do have strong revenue coming in, that you're making a profit, that you're not losing money. Again, the institutional, stable, long-term clients, having some of those on the books, having a well-trained staff, having, digital assets, lead generation assets, through a website, various online marketing tools, things of that nature. A plan in place, or a written plan, is a good idea to maximize client retention, as well as getting new clients, keeping the clients that we have, and really having great systems. It's one of the things that we've spent more and more time looking at and talking about, at our firm, are the systems and the processes that we have in place, that, people can take over. People know, this is how we do things. That being, a good intake process, good forms, good checklists, automated forms. There's a whole world of technology out there that really helps us be more efficient as attorneys. And if we have those processes in place, it makes things a lot easier, and something I think younger attorneys definitely, or someone looking at buying a practice, will want to look at.
Yeah, can they come in, and are there systems in place to make it easy for them to step in and handle the clients and run the business? There's a great book called The Power of a System by a New York med-mal lawyer named John Fisher, and he basically shares his office manual in the book. He also has a firm wiki page and is a big proponent in building out firm wiki pages. So if you have a new person join your firm or a new lawyer, where you have just like kind of a how-to guide of how your firm handles things, everything from like phone scripts to checklists to where you find forms to what to do when the printer's out of toner, so you're not getting interrupted with those questions. And you train your staff to look at the firm wiki page, and the staff is empowered to help build that out and take ownership of making sure there's kind of a best practice for everything you do in your firm. So exit strategy 3, hiring an associate to take over. And for the next 2, we're going to talk about some pros and cons. So one great pro is you have an ability to pick your successor. And this kind of thing that's very sacred to a lot of lawyers, the firm they built, to decide who's going to kind of handpick who might be running it. They can train and mentor to meet their own quality standards, to make sure clients are protected, and assure that the lawyer will practice with the same values that they have. When you hire an associate to take over a period of time, there's the built-in advantage that the associate gets to know your clients. So you can get more value for your practice because you can anticipate a higher client retention rate. And there's time for your associate to bond with your staff, which is important because, you know, a lot of us have great loyalty to the folks who've been helping us for years. And when you're the one who's transitioning out, you have you maybe have kind of an upper hand in setting the terms and deciding how your retirement timeline will look. And, you know, you can arrange for at some point the associate takes over as the owner of the firm, and then maybe you are kind of counsel with a fee split or paid a certain amount based on what you generate. There are a million ways you can do it, and you can kind of carve that to suit your own needs, and probably kind of are in the driver's seat on how you structure those terms. The cons of hiring an associate, as we said before, there's a limited talent pool in downstate Illinois, and the available lawyers may not have a whole bunch of cash to buy your firm. You also run into the eggs in one basket problem, which is, I think, the biggest problem about trying to hire an associate to take over. You may hire someone and it may take some time to see that they're not the best fit. It's really hard to judge hustle when you're making a hiring decision. The associate may struggle with generating business. They may want a job and not a career, and not to be a law firm owner. And especially with millennials, this is a trend. And then there are things that are like totally like outside of your control. They may get a better offer. Their spouse may be relocated. Because of the few young lawyers downstate, they may be tapped and offered an opportunity to take a senior role at a state's attorney's office or a judgeship. And you could invest all this time with an associate as your succession plan and then have it not work out. And then you're left starting over. I was actually approached by a lawyer who wanted to find a lawyer to take over his personal injury practice several years ago. It wasn't the right fit for me. I'm happy at my firm, but we talked, and I actually encouraged him to consider a different arrangement. And the lawyer they hired didn't work out. And now they're on another lawyer that may or may not work out. And if it doesn't, they're going to be starting from scratch 6 years out from, where they could have, when they could have had a totally different outcome if they would have handled it in a different way. So you may need to solve the eggs in one basket problem by hiring multiple associates, but your firm may not really be able to sustain that. And also, you may have a little bit of pushback on the timeline alignment, where a buyer may not want to wait as long as you want to stay around and handling most of your clients. And just anecdotally, when I think about Central Illinois, I can think of a lot more examples where this hasn't worked than examples of where it has worked. But so it's just kind of something to think about. Let's see. As to the fourth exit strategy, we'd like to talk about of counsel arrangements. So of counsel can mean a lot of different things. One common solution might be that an older lawyer might be joining a firm, bringing their staff, bringing their files, and then maybe they become either an equity partner or an income partner with just a fee split of what they generate, or maybe they'll pay a certain amount of rent for the space and just have the appearance of being part of the firm. There are a lot of ways you can structure it. but an of-counsel arrangement can have quite a few advantages. Matt, would you hit the... So some of the pros, you might have more options of who to associate with when you look at all of the established firms in your community. You have a lot more stability if you're relying on a team of lawyers than a single lawyer. It solves the eggs in one basket problem. You can find a longer term home for your staff and also maybe have the firm handle your physical files, which can be a big problem when you're trying to wind down and you've got a duty to hang on to these files. If you join a firm, instead of just an abrupt sale of a firm, and you practice there for a few years before you formally retire, it can create more stability for transitioning client files and improve the retention rate, which can improve the value you're paid over time. You get to mentor other lawyers if you're interested in that. And a part of that is you get to leverage other lawyers and profit from some of the revenue they would generate on your files. And when you are trying to look at different firms you might want to join, you have a lot of flexibility in negotiating that because you don't have to join them. So those are some of the pros. Some of the cons, you can run into like an old dog, new tricks problem where, when you join a firm, you are stepping in and using their software, their systems, their ways of doing things. And for a lot of us, that becomes harder the longer we practice. So transitioning from being like a lone wolf to part of a team isn't always easy for folks, but I think a lot of the advantages can outweigh the disadvantages. Another disadvantage is just less control of staffing, marketing, technology, your physical space. When you're a solo, you're the master of your own fate. You can pick all of these, you can control all these different things. And you'd likely have some influence on how these are done at the firm, but it wouldn't just be, you'd be dealing with decisions by committee or decisions by the other owners instead of just having total control. The other, from the client retention standpoint, if you make a move, you really want it to be one move. You don't want to move a bunch of times because that can erode the ability to retain client files. And then finally, your timeline may change. So I think the best practice, if you do an of-counsel arrangement, is to plan for the fact that plans may change. And you may go in thinking you've got a 2 or 3 year horizon, then you're going to go down to 20 hours a week. And you may try that and not like it and want more time. So it's a good idea to, in your plan with a firm, if you join, to talk about, well, what'll happen? Like, this is what I think will happen, but realistically, if I still want to practice longer, what will that look like? So you can kind of plan for plans to change.
So some things to consider when you are looking at arrangement like this. Of course, discussing revenue issues. Have a good, I guess, understanding between you and the new firm that you may or may not be joining on what expectations are, how things are going to work, how revenue splits are going to work, how that can benefit both parties. You want to make sure it's a good fit. Take some time to get to know the attorneys or the attorney that you're thinking about partnering with. Go to lunch with them. Just get to know everyone. Get to know the staff. Bring your staff. You want to make sure. As Josh said, you don't want to get into something and then have it not work out and have to come up with a new plan. So you really want to make sure that it's what you want to do and it's a good fit for everyone involved. Billing practices. Attorneys bill in different ways. Some attorneys send bills out every week. Some attorneys send out bills every month. Some attorneys send out bills whenever the client's trust accounts are low. And you want to make sure you have a good understanding of what the expectations are and what the practices are, and make sure everyone's on the same page. As Josh mentioned, understanding what your timeline, what your exit strategy timeline is, and building in for fluctuations in that if your plans do change, and put as much of this in writing as possible. I mean, again, we're attorneys, and we would certainly advise our clients to have a written agreement if they were going to do something, and we should follow our own advice.
Yeah, I think a lot of times we're victims of not following our own advice. A whole lot of partners just have it on a handshake, and but it can help to get it in writing. One last note about that fourth exit strategy. In a market like ours, where you have fewer young lawyers coming, fewer potential buyers, I think there's a strong probability that you can get more revenue for your book of business with an of-counsel arrangement, because there would be the ability for a firm to kind of pay origination on your clients for over time. So for a period of a certain percentage in your files for a certain period of years after you've transitioned out. So that can be an attractive element that kind of neglected to mention there. So a lot of this presentation is really directed at lawyers who are maybe looking to retire in the next 5, 7 years, 3 years. But we wanted to have at least a few things for the younger lawyers who would be on the presentation. So first, some advice for younger lawyers if you're considering joining, buying into, or taking over a practice. First, be really careful who you associate with, because if you join a firm and intend to take it over, you are also sort of inheriting some of the reputation of the firm in the local bar. Second, it's best to associate, if possible, with lawyers who are good at both the practice of law and the business of law. And in law school, they don't teach us anything about the business of running a law firm, and it's really hard. So you may not find in a potential firm that you may want to see promise in, or a lawyer you really like that you'd like to help be part of their succession plan. You may not find both of these in one person. You may find that someone's an excellent lawyer, maybe not great at the business side, or vice versa. And I guess what I'd say in those situations, we benefit in Central Illinois from having, and especially in the Decatur Bar Association, from having a very collegial, generous bar. And some of the best investment and time I've made in my career is just asking older lawyers if they would let me take them to lunch and get some advice. And there are certainly some I still intend to do that with in the near future, but that's just time really well spent, because you can develop kind of a group of mentors that you can lean on for help, either with case specific questions or law practice questions, or for how do I make the business side of this work? What should I be paying people? Like what should I be doing on marketing? What kind of profit margins should I be shooting for? These are hard questions, and we have a very generous bar and people who are really willing to share lessons learned. And then if you're going to buy a practice, you probably shouldn't represent yourself. And this is advice you would give any of your clients, but advice that sometimes is hard for us to take. And I think some younger lawyers worry that the seller may be put off by their wanting to, have their own lawyer. But I think really the fact that you would get your own counsel for that should only be a positive sign. It should show prudence and that you're being thoughtful and wanting to make sure you get it right. The ISBA has a lot of resources with information about buying a practice. We have some links in the website I sent around that we hope will help you. So I'd look there. Also, I was talking to a lawyer named Bryce Lynch in Clinton, who I really like, who I know went through this process where he kind of bought into a practice and intends to be a succession plan for a lawyer named Joe Taylor. And Bryce is really happy with how his process worked out. And he mentioned that he'd be very happy to talk to any lawyers considering this path. I saw Andrew Weatherford's on the call too. I think he's another success story about this kind of approach if you're buying into a practice or being a succession plan for an older lawyer. So there are folks you can talk to about how to make this work. And then the next is a little bit more about retirement planning. As a young lawyer, now I'm 40 now, but before, if I were asked like, how much do I need to retire? I would have had no idea. I would have no idea to where to even begin. So Matt and I wanted to suggest a few resources. One, there's a great book called The Richest Man in Babylon. It's a short book. It's like teaching through little parables. And one of the main ideas there is to pay yourself first. So what you've paid yourself is what you save and invest for your future, not what your take-home pay is. And that's an important distinction. Then the question, how much do I need to retire? Like, I had no idea. And there are a lot of answers, and the answers are different if you're in the public sector and you're gonna have a great pension than if you're having to create your own retirement funds. But one answer that at least gave me a place to start from, there's a legal finance writer called Mr. Money Mustache. It's a funny name, but he's got a lot of good stuff. And he says, if you assume that a 4% safe withdrawal rate, you really need 25 times what your annual spending is to retire. So I mentioned an article here, The Shockingly Simple Math Behind Early Retirement. I'd recommend taking a quick look at that, because it at least gives you one way of setting a goalpost. So it's not just this impossible uncertain number. It's a lot easier to chase a goal if you have a goal. So, and then the last thing, like we said earlier, based on the experience at our firm and just based on being smart to protect your family, protect your income, we'd really encourage you to get disability insurance. It's risky as can be not to.
So before we get into some of the steps in making a succession plan, wanted to talk about what happens if you don't. The worst possible case scenario is that you have no plan, that you pass away or become disabled, and everything is just left sort of dangling in the wind. Supreme Court Rule 776 talks about the appointment of a receiver in certain cases. The circuit court can appoint a receiver to wind up your practice for you. While that does help take care of your clients, it doesn't do any favors for you as the practitioner. The receiver's role is solely to look out for the clients and make sure that they're taken care of. It's not to sell your practice for you, not to preserve any value for your practice. They're not going to recover, any of your costs or act as a collection agency for you. Their job is not to, it's not like a trustee that they're trying to preserve the asset. They're basically not helping your estate, your family, you, or anyone, or they have no duty to you or to your employees. It's solely to make sure that your clients are taken care of. This is often from what I've read and what Josh and I have discussed, a very chaotic situation, and is certainly not the ideal route to go. So what can you do to make a succession plan, to plan for your retirement, or to plan for, I guess, the case of disability or death? The first thing you need to do is designate an attorney to take over for you. You need to have a way to notify your clients and determine if there is a need for immediate protective action. Again, this goes back to our duties, as attorneys of diligence. The Illinois Rules of Professional Conduct, Rule 1.3. We have a duty to, in a situation like this, designate a competent lawyer to take over for us, notify the clients, and determine what we need to do. So this is just another funny example of often what the succession plan is. Just hope for the best. So hopefully we don't end up doing that. So going back, so designating a lawyer, some considerations in doing so, you may think, well, I can designate Joe or Jim or whoever to, just take over for me. Well, is one lawyer enough? If the lawyer that you've designated as your emergency attorney or to take over for you has their own practice, are they too busy to take care of all of their clients and take all of your clients on as well? Do you need more than one attorney? Who should the person be? Obviously, someone that you trust, someone that has some familiarity with your practice area. You want to make sure, and they want to make sure that they have sufficient insurance, malpractice insurance, for the types of business that you might be transitioning over to them. Someone who can understand your systems. We've talked a little bit about the different systems and software and practice management systems that folks use. It's going to be difficult for someone to take over for you and be effective immediately if they've never seen your billing software, your client management software, your intake process, how your filing systems work, any of that. They should have a good understanding, and you want to make sure they have a good understanding of how your practice works. And of course, are they going to work well with your staff, your family? And a lot of times, family does end up getting involved, at least in the back end, for a short period of time if someone does pass away, and you want to make sure that as much as you can, you plan for that. So designated attorney tasks. So the attorney that takes over for you, what they are going to need to do is, of course, review your client files. And, the first step is determining, do you have any statute of limitations approaching? Do you have important deadlines, hearings coming up, filings, pleadings or motions that are due? They need to notify all of your clients of the attorney's death or disability. Handle any final billing for clients that are leaving. making sure that the billing process does continue for those that are not, which includes supervising trust accounting, making sure the trust account, is correct and disbursements are appropriate. Arrange for file storage. If you're a solo practitioner and you're not going to be practicing anymore, chances are you're not going to still have a building. So what happens to all of your personal or your paper files? They need to go somewhere. And handling payroll, making sure that your staff, if there is a plan of somewhere they're going to go, that's taken care of. If not, making sure that final compensation is paid out accordingly. You also need to think about how they're going to be compensated for this. Is there an expectation that they're going to take over your files if you're not available for a period of time or forever? How are you going to arrange a fee split? What are you going to do to make sure that they're paid for the efforts that they're making? It's not realistic if you have a large practice to expect another attorney to just take over for no compensation. That would be difficult for anyone to do. So, an option would be to pay them at an hourly rate. Another example, if you're a personal injury attorney and you have, contingency fees that are outstanding, and those are coming in, to work out a referral fee arrangement to where, they can take over for you and you can pay them a third of your fee. I mean, oftentimes, and we do that, firms and different attorneys have arrangements, throughout the community or throughout the state. If you're referring, a personal injury case to a firm, you're gonna work out an agreement to where you get a referral fee from their fee anyway. So this is a good example of what you can do as well if you're not going to be around anymore. Whatever the arrangement is, of course, it's always best to plan. And of course, we've talked about the importance of following our own advice and having, things in writing, some examples, letters, memorandums of understanding. There's some samples of some of this stuff too on the ISB website that you can all look at, and we're gonna have some links for you at the end of the presentation, or if you want to look at them later. But basically, just putting as much of it in writing as you possibly can. So also, you want to think about who's going to handle the day-to-day operations. If you're by yourself, oftentimes that's you, or maybe it's your staff person. In larger firms, there may be somebody that's already handling that for you. But it's something you have to think about who's gonna keep that wheel turning. You may not have the time right now to handle all of the matters in your office, but it's good to have a realistic expectation of who's going to keep track of the back end of your operation.
So,
Josh.
Yeah, I'd like to also talk about some of the things that you need to make sure. Like today, you may, have another lawyer who you trust, who you think is already on your mind as we're talking about this, about who would be a good fit for your designated attorney. And the plan should be more than just talking to another lawyer and saying, hey, why don't we be each other's designated attorney? There are some things you need to make sure your designated attorney knows. And I'll just kind of touch briefly on these. How does your calendar work? How do they get the list of your clients with their contact information so they actually can notify your clients? How do you organize your files? What do you retain in your closed files? Do you keep original wills, for instance? I mean, that can be a big burden if you have an abrupt office closure. Can they get into your computer systems? Will they have your practice management software? And you can also see there's a big difference in the situation if you have like a very loyal, long-serving office manager or paralegal who knows all this stuff and can help the designated attorney, versus if you're a true solo and a one-man band and you're the only guy who knows any of this stuff, then you should probably put all of it into a written succession plan document that can help them get the information they need. More on what they need to know, banking information for trust and operating accounts, like who is an authorized signer if you're unavailable. There's a limited POA in the materials that we're linking to where you can authorize the designated attorney to act for you. They need to know how you handle your time. Is it in your practice management service software? Is it in written ledgers? What would need, some lawyers may just have half a month of unbilled time. Some may have several months of unbilled time. And that unbilled time could be a significant asset of the firm that would be important to the lawyer and their family. And how do they want their receivables, their past due bills handled? Who's their accountant? Who's your bookkeeper? And what vendor information or leases on equipment, for what kind of insurance information? Who do they need to contact if they're going to try to wind up your practice? How do you handle your payroll? Do you use a service for that? Do you pay it? What do you pay your people? What do you want done with your long-term staff? How long should they keep them on the payroll? Do you want them to get a severance if you're unexpectedly forced to close? How long do you want your office to stay open? You may handle several types of cases, and your designated lawyer may only handle a small subset of those cases. So you may have a couple preferred family lawyers, estate planning lawyers, probate lawyers, PI lawyers in mind that would be folks that you would want to handle your files. And it'd be a good idea to give your designated attorney a list of like the priority and who should be contacted to transition some of those files that are outside of the designated attorney's practice areas. And then, should you purchase tail coverage for your insurance? Should they attempt to sell your practice for you? And if so, what kind of parameters are you giving them on like who might, maybe you already know of potential buyers if something were to happen?
And one thing that you could or should do, or in order to make this transition to the successor attorney a little easier, is to let your clients know now, at least in writing, or at least attach something to your fee agreement or your retainer agreement that lets your client know what's going to happen in the event that you're unable to take care of their needs. We've included here some suggested pros from the ISBA website. They have a couple of other examples there, but basically you're letting your client know now that if something were abruptly to happen to you and you weren't able to pursue their case or continue with representation, at least in the short term, that you have someone designated to take over for them. They understand that person's going to take over for you until such a time as they decide to stay or find a different attorney. Of course, that's always up to them, but you want to let them know that there's an immediate plan in place to take care of them. It's not a bad idea to have a calendar. This again is an example from the ISBA website of a sample calendar from notification of the clients all the way through the wrapping up or closing up of the office. There are some other samples there, but just kind of looking at some of the basic steps that need to be taken and to have a plan in place to take those steps.
I know a lot of our talk has been the kind of worst case scenario that something abrupt happens to you and you're never going to return to your practice. If you're going to take the time to put a written plan in place, and we think you should, we'd encourage you to also take a little bit of additional time to think about different scenarios, because you may only be unable to practice for a few months. And it's a good idea to have both what we would think of as more of a contingency plan in addition to your succession plan. So you think about like if you were going to be out for just a few months, and what would you want done differently than if it were a true succession plan? So a few differences in the next slide, Matt. You would want to think more about managing files and transitioning files, or retaining clients instead of finding them new homes. Or maybe if you're going to be out for 3 months, maybe you have some that are in very active contentious litigation, a subset of files that need to be transferred for someone who can handle those pressing needs or pending deadlines. What do you want to do about maintaining your staff? And do you want to keep the office open or reduce the hours to cut costs? Another thing you can do in that kind of situation is explore having an of counsel agreement with other lawyers that would kind of come into effect if someone were to become disabled. So they can come in and handle some of your files on a kind of shorter term basis. Matt and I, when we sat down to try to put this stuff together for you guys, we really wanted to be able to leave you with everything that you would need to build your own succession plan. And the really good news is some guys are a lot smarter than us with the ISBA have gone to this trouble, and they've put together fantastic resources as a group. So you'd have the benefit of a lot of lawyers who spend a lot of time thinking about this, with many different checklists, sample plans, sample language for corporate resolutions, for your own estate plans, POAs. A lot of this is at the website we mentioned here. We link to all of this stuff on the succession planning page we just put on our own website. So you have kind of a one-stop shop with these slides and with links to all of these important documents. But a great first place to go is that succession planning website. Next, because this has become a bigger priority of the State Bar Association, and they have put out a proposed rule that the Assembly's approved that the State Supreme Court hasn't adopted yet about the designated attorney role. They've really been dialing up the time they've been spending on producing CLE materials for lawyers. So if you'd like more on this topic, there are 5 or 6 different presentations that are longer by folks who are involved in those committees, and we've got a list of these here for you. And each of those, has other materials that might be helpful to you. Probably the best deep dive on this stuff is a full book that was published by the ABA. It's Olmstead on succession planning, and you can get that through the ABA's bookstore. So if you know that this is coming up for you in the next 4 or 5 years, it might be worth investing a little bit in that book just to read this issue spot. It's be a wealth of ideas for you on how to orchestrate this in the best possible way to meet your needs. Well, we really appreciate your time and you coming to this presentation. Matt and I just want to thank you, and we hope that the materials we've given you are helpful. Again, the links to all of the stuff that we've talked about and referenced that you would need to put together your own plan, including sample plans and checklists and sample calendars, are all linked from Bree-Law/Succession. So we hope you'll check that out. When we get the recording here, I believe it'll be on the DBA website, but we'll also plan to put it on our website. And I think we have a few minutes left. We'd certainly welcome any questions anyone might have.